Okay, so it's noon now. We're going to get started because there is a lot of content to cover today, and I know a lot of people on this chat now. Some people submitted questions in advance. Some people have their questions and have brought them today. There's a lot of questions to go through, so let's jump right in and get started with today's session. My name is Bailey. I'm the co-founder and president of Redstone Agency. Most of you know me. A lot of clients on this digital roundtable discussion today, but there are some new faces and new names that we'll see today. I did want to let everybody know that we do have some vendors joining us. We have others in the event industry joining us. So we are going to try our best to keep the questions as specific as possible, yet still relevant to everyone that's on the call today. Redstone is an event and association management company. We run events and manage associations across Canada and across the world. One of our core values, I'll tell you all of them, are impact, trust, extra mile, and people. And being true to our core values, it was important to us and is always important to us, but now especially to be as proactive as possible with the services we offer. And that's why today is our first, which we're hoping of many, digital roundtable discussions to make sure that we stay connected, to make sure that you have the information you need as association leaders, as industry leaders, to kind of bring everything into this new world, but then beyond that as well. And we want to be here to support you and be part of that. So we're going to try to offer as much content as possible. If you have ideas or if there's anything you want to talk about with others, please feel free to share ideas with us and we'll make it happen. So I want to jump in and introduce the panelists to you. The format for today will be, we'll do quick introductions. I'll jump in by, I'll start off by asking each panelist a question. They'll do a brief introduction. They'll answer the question, and then we're really going to open up the floor to the questions that we've received and the questions that you have today. I've compiled the questions we've received already, so I may call on you if you're on the line to ask your question, just so you don't hear me talking the whole time. But if you have questions because you have not submitted them yet, please feel free to enter them into the Zoom group chat. You can send them directly to me so I can see them and I can ask them, or I can call on you if it's not coming up as a question later on in the session. So let's get started. If you have any questions throughout or you're having tech difficulties, just let us know as well. And I have Caitlin on the line with me and she will help you out. So let's start with Nadine. Nadine is a partner at Hicks Morley, the leading labor and employment law firm here in Canada. She provides advice and representation to public and private sector employers on a wide range of labor and employment issues. Over the past few weeks, she's been one of the leads from her firm on the COVID-19 crisis, and as much as you could be an expert in this area, I would say that Nadine is becoming the expert on this. Welcome, Nadine. Jonathan Roth is a litigator with expertise in contractual interpretation. Having worked at a big Bay Street firm, as well as a clerk at the Court of Appeal and as Crown Counsel at the Justice Department, Jonathan has been involved in litigation matters from all ends. Much like Nadine, his practice over the past few weeks has been navigating contractual obligations and negotiating favorable outcomes for his clients. Thanks, Jonathan, for being here with us today. And finally, we have Heather Reed, the founder and CEO of Planner Protect. She has a very unique perspective on today's panel, as she will be the expert you want to hear from for guidance on next steps and navigating your contracts when the COVID-19 crisis is behind us. Many of the questions we received were, what's next and how do we protect ourselves moving forward? So we're really lucky to have Heather here with us to guide us through that. So let's start with opening comments from our panelists and questions. So the first question will go to you, Jonathan. What is force majeure, and what are some of the differences you've seen with this clause in the contracts you've been reviewing for clients over the past few weeks?
Thanks, Bailey, for the introduction, and thank you to Bailey, Carly, and everyone at Redstone for hosting what I think is a timely event. And thank you to all the participants for taking the time to come out. If there's something we can do to help, we're happy to do it. It's a bit of an unprecedented set of circumstances. So, if any of our advice can be helpful to you, I think I speak for everyone when I say that we're happy to do it. Force majeure is basically a contractual provision that excuses a party's non-performance of the contract where there is a set of events or an occurrence that makes it impossible to perform. And I've seen excuse me, a renewed interest in this provision with everything that's going on with the current pandemic. And the first question that everybody has to ask if if they have a contract and they're worried about performance of the contract is, do I have a force majeure provision? And that's an important question because courts are reluctant to imply those provisions where they aren't specifically included in a contract. So unlike other types of contractual provisions that courts from time to time imply or read into an agreement, even if they're not specifically set out, courts typically do not do that with force majeure clauses. So it's important to sort of start out by giving consideration to whether your contract has such a clause. And keep in mind that if it doesn't, you're not necessarily out of luck as somebody who would like to invoke such a clause, because there's a common law doctrine that is quite similar, and that's called frustration of contract. And that can arise even in the absence of a force majeure clause, where there is some event that goes to the heart of the contract and makes sort of the purpose of that frustrates, I should say, the purpose of the contract. So those are kind of the initial considerations. And I hope, as we go forward and deal with some of the specific questions, we'll get into kind of the force majeure analysis and some of the things to look out for, when you look at your particular contractual language.
Thank you. That's great. And opening comments and questions to Heather. Many of our clients are having trouble renegotiating their contracts in the current climate, either because there's still so much uncertainty or because there's no effort to come to the table by the venue. What advice would you give people at this time?
Thanks, Bailey. Really, truly, I think the first piece of advice is to have patience. I don't think some of these events are going to happen anytime soon, and I think it would be prudent of all of us to just kind of hit that pause button and not make a hasty or knee-jerk kind of decision. And as a planner, I understand completely that we want to know when and where our things are going to happen next. But I really think that we need to exercise some patience. And I say that because I think there are some that have canceled their events or tried to postpone their events, and everything is very fluid. Hour by hour, things are changing, and our brands, our supplier partners are having to adapt just the same as we are, and things are changing for them as well. And so the initial reaction of not being willing to accept a force majeure, the willing, it's a straight cancellation as opposed to a force majeure, which it has been up until recently, then, we're seeing a change because now it has become. And so where it is more, there are provinces, there are cities that have invoked no more than 50 people gathering together, that sort of thing. So I really think the very first thing is to exercise some patience and realize that this is going to be a long process in sorting out. So that's my first reaction to that is, and I think sometimes we may not want to respond in the same way that we've been responded to. And I say that in that, some venues have been difficult to work with and holding us to the letter of the contract. There are actually, I've heard of, some of our supplier partners that are sending out invoices for quoted equipment, not necessarily contracted equipment. So I think there's a lot of that reactionary that we need to just step back. I would suggest that just this morning I learned of the first layoff from our venue partners. So some of our reps aren't even going to be in place if we want to continue the negotiations. And so I think, that in itself is going to cause some, just a stop of what we're doing, because we're not even going to know who to contact, in the next little while as venues go through what are their courses of action. The one thing I did just, I have lots of other suggestions, but to answer the specific question, if you have the availability of a national person that you can connect with, if it's a major brand, if it's particularly a hotel situation that you're dealing with, I would suggest connecting with your national contact or finding that person, because I think they have the big picture in mind of what the value of your piece of business is, that maybe a one-off venue that is being hurt right at the moment may not take the time or the pause to see the bigger picture and realize the value of the business that you're bringing. So that would be my overall big picture response to that, Bailey.
Okay, great. Thank you, Heather. And you brought up a really relevant piece, which is the employer side, and we're lucky to have Nadine with us. Nadine, employers are facing some really difficult decisions right now. What are the most frequently asked questions you're getting right now, and how have you been guiding your clients?
Okay, yeah, so thanks for having me, Bailey and Carly, and everyone at Redstone. It's great to be here and happy to share my knowledge. So I guess my first comment would probably echo a bit what Heather was saying, which is that things are constantly in flux right now. And the questions we're getting now are different than the questions we were getting a week ago. A week ago, it was more about, the travel restrictions and what can we do about, kind of putting restrictions in place or asking employees about their travel. Now the questions are which employees can come to work, which employees should come to work. Can I force someone not to come, or can I, require someone to come? And those are, again, all constantly changing. And, with respect to those questions, I think we need to heed the advice of our public health authorities. They're the ones providing that health-related advice as to who is safe to be in the presence of others and who should be self-isolating. But, to the extent they're saying that someone is not required to self-isolate, arguably they are still allowed to come to work. And then there's just this general overall pressure, I think, from everyone that we're trying to heed the advice of what all of the medical authorities are saying, which is try to the extent you can, social distance and remain at home, which is really challenging for a number of employers who just simply can't function when their employees are at home, or they have a public facing role. So those are kind of, I'd say, the first questions we're getting. Then the question becomes to, okay, well, if employees are off work or not coming into the office, do they have to be paid or not? Obviously that's a big question, particularly for smaller organizations or organizations that just simply can't afford to continue to keep people on payroll. And so, the question is there a requirement to pay when they're off? Or, even if there's no requirement, should we be offering to pay for at least, the foreseeable future, given that no one really knows how long this may last? And from a legal perspective, for the most part, and I will caution this, say for the most part, there is no requirement to pay employees who are not working. There have been some measures that have been introduced from some governments across the country that seem to be coming down the pipe, which may provide for some paid leaves. But for the most part, there is not an entitlement to a paid leave. Employees may have entitlements under sick plans. They may have other, paid days that they can bank on. But I would say, cautiously, generally speaking, there's no legal requirement to pay. That being said, if you don't pay an employee and they're not on, sort of a protected leave, then you do run the risk of a constructive dismissal. There is no right in an employment relationship unless you've contracted for that right to temporarily lay off employees, and people find that quite surprising sometimes. But it is worked into pretty much all of our statutes across the country, that there is some sort of statutory right to temporarily lay off employees, but there's no common law right to do so. So unless you have that in your employment contracts or policies, arguably to do so is going to amount to a constructive dismissal. It remains to be seen whether people will actually, take employers up on that. And I think that'll probably depend on how long these temporary layoffs are going to last. But certainly in the last few days or the past week, the focus has turned, with respect to my clients at least, to temporary layoffs and potentially actually terminations of employment.
Yeah. Okay, thank you, Nadine. Okay, so we're going to jump right into our roundtable discussion. Like I mentioned before, we have received a lot of questions in advance. So if you're on the line, I may call on you to ask your question just so we get some more people talking. If you have not submitted your question in advance, there is that chat box feature. Please feel free to send that to me directly so I can build it into the flow for today's session, and just make sure we're not asking the same questions twice. We will unmute the line now, but if you do not plan to ask a question, please keep yourself on mute. Just it avoids extra background noise. In your box where you can see your face or you can see your name, there is the option you'll see when you put your cursor over to mute yourself. So please do that if you're not planning to ask a question, or even if you are planning to ask a question, you can also mute yourself and then unmute when you're ready to ask. But just make sure you hit the unmute button that's either in that box, or you can also find it at the bottom of your screen. If you put your cursor over the bottom, you'll see a mute button on the leftmost corner. So we're going to start off. I'm actually going to ask the question on behalf of a client, Jennifer Hamilton, from the Canadian Association of College and University Student Services. I thought it was a good way to kick off this discussion. So Jennifer was wondering if Jonathan and Heather, you could elaborate a little bit more on force majeure and impossibility clauses. Just if you can explain a little bit further what those mean. Maybe Heather, we'll start with you, and Jonathan, if you have anything to add, please do so.
Sure, happy to. So my understanding, not being legal counsel, but a seasoned planner, is that the force majeure, and actually there are a number of different terms that could be used for it: impossibility, acts of God. It's not necessarily always called force majeure in a contract. So know that first and foremost. It may be something else that the legal team has called it. But the concept is that something that has been unanticipated or unknown has burdened the performance of the contract from either side. That's my understanding. And in this case, certainly a pandemic would be something that would be considered as unanticipated months ago. Now it's not necessarily unanticipated, and so timing obviously is a factor. But my understanding is that impossibility is a black and white objective decision that it absolutely is there is no ability to either host an event or to deliver an event. So either the venue perspective or the event host perspective. There's also a level of force majeure. There are 3 levels. The second level is called impracticability. And it took me a long time to say that word, but it's called impracticability, in that your ability to fully perform the extent or the obligations of your contract are in some way hampered. They're in some way less than ideal. And that may be where your ability to bring attendees into an event has been in some way obstructed. So if you think about transportation hubs being closed down due to a threat of terrorism, that if 60% of your attendees are international and coming into a major center, that your ability to 100% perform the contract is inhibited in some manner. So that is called impracticability. And then, as Jonathan suggested, there's a concept called frustration of purpose. And that's a very narrow definition or part of the force majeure clause. And that's where there is an ability of both parties to hold the event or the venue to host the event. However, the reason for hosting has become frustrated, and I don't have a quick word for like a substitute for that word. But for an example, a client that I have worked with had a Japanese-Canadian alliance event happening in March, and half of the attendees were Japanese and unable to travel. And so they were able to claim frustration of purpose because the sole intent was for 2 different audiences to gather. So I think that's my understanding. I would certainly turn it over to legal counsel who has a better, probably more robust explanation than I.
Thanks, Heather. I'll jump in here. I agree with what's been said, but I think that the focus has to be on the particular language in the contract. So the first question to consider is, does this pandemic qualify as an event that triggers the force majeure clause? And that will depend on the language that you have in your agreement. So you may be fortunate, if you're looking to invoke such a clause, you may be fortunate to have the language pandemic in your clause. You may have a clause that refers to the outbreak of illness. If you're lucky enough to have that kind of language, then you shouldn't have a lot of trouble making the argument that the pandemic is captured by your provision. But many provisions are not as specific as that. They may include, a couple of non-exhaustive examples that don't include pandemic. They may refer to, they may refer broadly to unanticipated events that are beyond, either party's control. And then it's a question of sort of whether the pandemic is captured by the specific language. I tend to be of the view that although courts interpret these clauses narrowly, with the scale and the scope of what's going on, it shouldn't be that difficult to make the argument that this pandemic qualifies, even if it's not specifically referred to as in your clause, on the basis that this is clearly beyond the control of the parties. There's no question about that. In most agreements, neither party is going to have had any control over this whatsoever. And so even if you don't have specific language, you may still find that this event is captured in your provision. And the same is true with respect to the language of your provision when it comes to whether the threshold has been met in terms of illegality or impossibility or impracticability. And Heather referred to all these various terms. Some clauses will refer to a set of circumstances having become illegal. And in that case, with respect to events in particular, the analysis will then turn to whether various orders of government have prohibited certain large gatherings and actually made it illegal to host certain events. But then, as Heather mentioned, there's other language that you might find, impossibility being quite common, and that will be a more complex inquiry into whether or not this pandemic has actually rendered performance impossible or not.
Great, thank you. So we have Val on the line today from the Canadian Network of Asset Managers. Val, if you want to come off mute, Val had two really great questions that I thought she would share. I think there were a lot of people that asked very similar questions. So Val, I'll give you the floor if you want to ask the two questions that your association had.
Sure. Thanks very much. I'm glad that I had the opportunity to partake in this roundtable today. My first question is, where force majeure is being invoked, is it the responsibility of the party claiming force majeure to prove the conditions are met, or is it the responsibility of the other party to prove that the claiming party has not met the conditions of force majeure? Maybe I'll just stop there. That's a big question.
So Jonathan, I thought we could maybe start with you on this one.
Sure. So typically it's going to be the party invoking the clause that is going to bear the burden of establishing that. And so I would say this, whether or not the party invoking the clause is a plaintiff seeking to recover, under a contract, or the defendant raising the clause as a defense to non-performance of the contract, typically it's going to be the party that's relying on the clause that will have the burden of establishing that. But again, that's really going to come into play for those disputes that either sort of become claims, actual claims in court to be decided or subject to arbitration in some cases. And it's important to understand that if you are a party that is looking to rely on such a clause, it may be that you will inevitably bear the burden of having to establish that in, if your dispute goes to that stage. But, that doesn't mean that when at the time that you invoke it, for example, in a negotiation with the other side, that you bear a specific burden at that time. It's one thing to sort of involve these types of arguments in your negotiations, and it's another to actually have the burden of proving them on the balance of probabilities in court or in an arbitration.
Okay, great, thank you. The other question I had is, how does a reasonableness test get applied to a force majeure clause? And I have a somewhat specific example where the clause may contain a reference specific to the city the event is being held in and a notice period prior to the event. And with something like COVID-19, where it is not possible for us to know or predict when the public health officials may lift travel restrictions, how can a reasonable test come into play at all? Or can it come into play, and how? And I guess I'm thinking about, we've heard some more recent orders, emergency orders for some provinces that have said no gatherings. So, where does that put us? And that's indefinite. We don't have a timeline on that.
Heather, did you have any comments on that one, or did?
This is your domain, Jonathan.
Yeah. And I feel like it's sort of like uncharted waters a little bit. So, I mean, yeah, Jonathan, if you want to take your best stab at that question, I know it's like a tough one without knowing exactly, can't really rely on a lot, right?
Yeah, so I don't typically think of the analysis as sort of being a reasonableness type test, as you find in other sort of areas of law where there's a specific reasonableness analysis that is that is really has to be considered. I think of it as I mentioned, there are a few elements that you have to consider if you are trying to. By the same token, if you are trying to ensure performance of your contract in the face of someone else invoking a clause, and those considerations are really, A, does your event qualify? Have you reached the threshold of illegality or impossibility that we spoke about? And the other thing I mentioned is because it came up in the context of the question, is notice requirements. So oftentimes you will find with force majeure clauses that there are notice requirements. So you might see a provision that says that notice has to be given if you're relying on the clause within 10 days of the occurrence. That raises difficult questions, because this is not a situation where there's a one-time occurrence. It's not a situation like for example, a terrorist attack where you can pinpoint the exact time at which it occurred. This is an evolving situation. I think Nadine talked about things being in flux right now, and it's every day there's new information and there are new declarations by different orders of government. So it's very difficult to pinpoint when those notice provisions actually start to take effect. And that's something that, I think from a practical perspective, it's better to give notice sooner rather than later, because you want to make sure that you're not, if you're invoking a clause, you're not subject to an argument that you have waived your ability to rely on the clause because you didn't give notice within the specified period.
Jonathan, I'm wondering if I can add something and also have your opinion. So I know from reviewing a lot of contracts and working with the clients, there's two kind of periods of time that are seen. One is that notice needs to be given within 10 days, for example. But the other one is that some clauses say that the situation has to be within 30 days of the first day of your event. And so I'm wondering if people need to look carefully at which period of time is being referenced. Is it solely about when does notification need to be given so that when you become aware of something, you have 10 days to act upon it? Or is the wording, or maybe it's not an or, maybe it's an and, in your language, is it saying that the force majeure event has to be within a certain period of time before the first date. So I think just based on what I've seen in contracts, I think there's two different windows that need to be, like, go back and look at the language and say, which one is this about?
I think, yeah, I think that's quite right.
Phew!
We're on the same page. Okay, so I'm going to bring the conversation over to Nadine a little bit more. We do have quite a few more questions, some through the chat and some still in my list on, different jurisdictions, Canada, US. So we will get to those too, but I do want to give the floor over to Lloyd Talbot, who I think is on the call with us, who had a question for Nadine. Lloyd, if you want to come off mute and ask your question, please do so.
Yeah, it relates to personnel management. If an individual has handed in a resignation and then goes back to the employer and says, because of this resignation, I'm not going to qualify for certain benefits and so on, can that person rescind their resignation, or is it up to the employer to make that decision?
So good question, and we're actually getting a lot of questions recently about rescinding not necessarily resignations, but offer letters and delaying start dates and things like that. So it's definitely topical right now. In terms of a resignation, it'll really depend on whether the employer has actually accepted the resignation formally. Because once you've accepted it, that essentially means that you have a contract, and it's very challenging at that point for the employee to back out of it. I guess if it's a situation where the employer wants to assist the employee to, provide them with a better opportunity to perhaps claim EI benefits. I mean, we can't tell what EI is going to do, but obviously if it's a resignation, they're much less likely to be able to claim EI benefits. So if the employer is on board with that, then you may be able to kind of essentially revise your agreement and allow them to rescind that resignation and turn it into a termination. It'll also depend on when the resignation was supposed to be effective, because obviously if they're still working because the resignation date is a month or two from now or something like that, and you're going to be laying off employees anyway, then it may not quite matter, because that'll happen before the actual resignation date.
Thank you, Nadine. We also actually had a follow-up question to that. I know some employers were considering like giving people the option to kind of take a step back or to try to help out with workforce before more, before the stimulus package was announced, where there was going to be more benefits for employees. Would that change anything? Like if someone offered, to take, they were older, they wanted to be home, they offered, I don't know, like you don't really offer to resign, but they offered to take a leave, and it came from them. But now with everything changing, if that changes anything.
So you mean someone who has previously indicated that they want to take a leave or were intending to,
I mean, based on what's going
reduce
on now,
hours or something like that.
Yeah, based on what's going on now, they
situation.
offer to take on a reduced workload or to do their part. We have seen some of that. So like with that, now that there's more being offered in the form of EI, would that change anything for an employee?
I mean, it depends. I think it would depend on the circumstances. I mean, if they can say, look, I put that forward, I made that agreement based on an entirely different set of circumstances, then, I think the position could certainly be taken that that's not exactly what's going on now. And we have an opportunity to revisit that and kind of renegotiate that. But, arguably, if that arrangement was already in place well before we could foresee any of this, then that's their new terms of employment, and that's kind of the way in which they've been operating on at this point, and that's what's going to be in place at, going forward.
Okay, great. Nadine, I actually had another question for you, but I want to help you with a little bit of the tech challenge we're hearing with your sound, which we're going to do. Okay. But I'm going to skip a question. I'm going to go to Richard Robertson from CAM if he's on the line. Richard had a question that I thought Heather or Jonathan might be in the best position to answer. Richard, are you on the line with us? Okay, I'm going to ask the question for Richard on his behalf. Richard asked, are there situations where a deposit on a venue for an event that's supposed to take place in the next 3 months should be totally refunded instead of offering future credit? So I think this question came from a lot of the conversations we're having with properties now is that they're willing to delay, they're willing to do something later in the year. Or next year even, we're starting to see some venues saying, okay, we'll start to consider 2021, 2022. But what happens, like could there be an argument, or should there be an argument that really there should just be a refund? And, let's use nurses, for example, or education. We have a lot of clients in those spaces where the reality is we don't know if they can do an event in 2020. That's the optics of doing an event, the personnel available to participate in the event, all of that. So can you provide any guidance there?
I'll jump in, and then again, hopefully backed up by Jonathan or a different perspective. But I know in a lot of contracts, it comes down to the nuances of the words that are specifically referencing the deposit amount. I know that often the deposit will say that it's a non-refundable deposit. And the advice would be that there were additional words that said, except in the case of force majeure, so that there's a qualifier there that specifically under a certain situation, your deposit is non-refundable. So I think there's an opportunity first to look at the actual language that you have. And if you are claiming and able to show evidence of force majeure or land on that, then obviously that would be a straightforward return of your deposit. But I would think that unless it's been strategically negotiated that way, then you're going to have to find a resolution that works for both. And I wouldn't say that it's necessarily the venue's responsibility to return it to you, but to find a solution to move it forward to a future event. But I would leave that to John. That would be my initial reaction to that question.
I tend to agree with that. I think it's going to come down to it's sort of a case-by-case situation. And I think the other reality, and I think Heather's response sort of touched on this, is a lot of these types of relationships, they're going to be ongoing relationships. So there is, it's in everybody's interest to try to come to some sort of resolution that works for everybody, that's mutually agreeable. Because, going back again to this situation of an event that's been canceled, because I think that's relevant to many people on the line. These events that they will happen in the future. People will come again. It's a matter of time. Obviously, nobody knows how long it will take, but the events will go on. And so the relationships between the parties are going to still be important. And especially in terms of, if we're talking about, deposits or other amounts, I mean, obviously they can be substantial, but I think it's in everybody's interest to try to, resolve these and recognize that we're in a situation that is very much unprecedented, and people should try to work together to resolve it rather than take positions that are likely to lead to disputes.
Yes, thank you. Okay, let's try going back to Nadine. We're hoping we had a little bit of a resolution. Nadine, we got an anonymous question. My understanding is that a layoff can only last 13 weeks. Is this true? And what if this pandemic lasts longer?
Okay, so hopefully you can hear me. The 13 weeks that I suspect you're referring to is from the Employment Standards Act in Ontario. So every province has different employment standards legislation, so it will differ by province. In Ontario, there is temporary layoff language, which says that if you temporarily lay off an employee for up to 13 weeks out of 20, then that does not constitute a termination of employment. So once you exceed that 13-week period, then it would automatically amount to a termination of employment, going back to the first day of the layoff. So As I said in my opening comments, that's all subject, of course, to you having the right to actually temporarily lay off an employee, which is not an implied right in any employment contract. You can extend that temporary layoff period, and there are provisions to do so under the Employment Standards Act. So it can extend to up to 35 weeks and 52. There's various ways in which you can do that. The most common ways are either to continue paying what the legislation refers to as substantial payments to an employee. So some form of payment. It doesn't necessarily have to be their full salary, but some payments to the employee. Continuing pension or benefit payments on behalf of that employee, so continuing their benefits during that period, for example, or with a written agreement with the employee to extend that period of temporary layoff up to 35 weeks and 52.
Okay, great, thank you.
And just obviously keep in mind, if you're talking about other jurisdictions, there is different language in every statute, which I don't have time to go through given all the provinces, but make sure you're looking at the appropriate statute.
Okay, great, thank you. And we received another question. I think it might be around morale, and if the individual asked is on the call, feel free to jump in and ask more about it. But we got a question about how to manage staff during this time. I interpreted this as more of a morale question. I don't know if you can provide guidance here. Maybe this is just, it could just be managing payroll. I'm not sure, but I don't know. What would you respond to a question like that?
Yeah, I mean, I think we're all sort of struggling with the new reality and figuring out how we can manage our business or our employees through this time. So there's obviously a number of considerations that are coming up. First of all, I mean, I think you're right, employee morale. I would say reach out to your employees. It's a lot more challenging to do so when they're not in your office, but taking that time to make sure you're connecting with your employees in whatever way you can. Providing them with information and access to whatever EAP resources you have or other resources that can be made available to them, because obviously it's a very difficult time for all employees. I mean, for all of us, but whatever supports you have available to your employees, you should be making sure that they're aware of them right now. And then in terms of, I think, the logistical issues, I mean, there's the kind of business planning issues that you're going to have to deal with in terms of how do we send out letters and how do we manage payroll and those kind of technical issues. But there's also the issue that now a number of workforces that previously were not operating with employees working from home are now operating with employees working from home. And so there's a number of issues that you need to consider with that in terms of how are you going to manage the work and whether they're actually able to do work, particularly given the fact that schools and daycares are closed. So a lot of them are battling childcare issues as well. Other things to consider, I would say, are IT issues. So do you have the IT support to support everyone working remotely? Have you considered cybersecurity issues and how that now changes given that they're not all tied to your physical network, but they're all now working remotely? And really just how are you going to check in on work being completed and conduct those meetings? And technology is great, so we have a lot of resources available, but I think it's just sitting down and actually going through the technical and logistical challenges of a lot of it and figuring out how you can go forward on an interim basis right now, but keeping in mind that no one really knows how long this is going to last, so planning ahead as well.
Thank you, Nadine. We have Erin Clarefield on the line who had a question for you, Jonathan. Erin, if you want to come off mute, feel free to do so now. Otherwise, I can ask on your behalf.
Sure. Hey, guys, thanks for taking the time. I guess my question was really from a bit of a legal perspective. Does the World Health Organization declaration that this is a pandemic apply to contract interpretation? Or would the country in which the contract is enforceable, so we do a lot of Canadian, US, worldwide business, need to actually declare it a pandemic? And quite frankly, I have no clue if anyone has, from a country basis, called it a pandemic other than in news conferences, etc.
So, the simple answer is I do think that it's relevant. I think it's relevant in a couple of ways. I think if you are dealing with a clause that makes reference to a pandemic, certainly the declaration by the WHO of a pandemic would be significant for that purpose. But I think the other place that it comes into play is we spoke earlier about the notice provisions and sort of when does this time, if you've got a timeline to give notice, when does it start to run? And I would think that a significant declaration by an organization like the World Health Organization, could be the point in time when that timeline actually starts to run. So it's not unreasonable, in my view, to look at that kind of significant declaration and say, well, now that it's crossed over to this territory of being having been declared a pandemic. This is now the time when notice should have been given, and I wouldn't be surprised if there are some parties who are looking for performance of contracts. In other words, they are on the opposite end of a party invoking a clause. I wouldn't be surprised if some of them took the position that if notice was not given within a certain amount of time after such a declaration, that actually the party has waived their ability to rely on it. So all of this is to say that when it comes to giving notice, in my view, sooner is better, and consideration should be given when organizations like the WHO make those kinds of declarations.
Jonathan, if I might, I know being a student of cases and things like that, and really laser focused on contracts, I know that when Hurricane Irma, so another force majeure that would have invoked some terminations of contracts, one of the major learnings that came out after that was that unless there is that window of time built into the language of the contract clause, that there was case precedent that clients were not off the hook unless that hurricane had happened on the days of their event, because there wasn't that window of time ahead of that this could have been invoked. And so I wonder, like, I know it's open to speculation and this is a new day, but I would caution that was one of the major learnings that came out of after Hurricane Irma, because there were clients that were left holding, they didn't want to do business. I know of an incentive travel house that was taking a client down to Florida in October, and of course the hurricane hit in September, and they were not able to claim force majeure because it fell down to those 6 words that were missing about the period of time in advance. So I just wonder, I know it's still unknown, but I would caution moving forward, that would be one of my major takeaways, is to always build in a window of time ahead of your event to which you can invoke a force majeure clause. Otherwise, the interpretation at the time was that it had to happen on the days of the event.
Thank you. Thank you both for that. Nadine, I have one more question for you that came in very recently before our session. I don't know who it's from. It was an anonymous question. So someone recently told me there was a work share program where 2 employees could share one job 50-50 and collect EI for the other 50. Is this right?
So good question, and this is becoming, I would say, more topical these days because there was an announcement with respect to this program in the announcements that came out on Tuesday from the federal government. So there is a work sharing program that's set up through Service Canada that has been in place for a while. That's not a new program. And it's basically a government program that's designed to help employers and employees avoid layoffs where there's a temporary reduction in business beyond the control of the employer. So it provides income support to employees who agree to a temporarily reduced work week and to share the available work on a 50-50 basis. So basically 2 of them would be performing one job, each of them performing 50% of it, and then EI would top up the rest of it. So they're essentially sharing the EI as well. So the new announcements on that were that the period of time in which it can extend has been extended to 76 weeks from 38. And the application process is apparently going to be streamlined. We don't really know what that means at this point, but it is, up until now, it's a 30-day period in which you have to submit your application. So 30 days before the required start date of the program, which is obviously going to be challenging for anyone right now. It's unclear right now whether they're actually going to waive that 30-day period and kind of enter into these agreements more quickly. So we're waiting for news on that. But yes, you're right. There is that program out there that you may potentially be able to avail yourselves of. And it is a relatively complex application. It's not just sort of a tick the box thing. So I would recommend that you do get some assistance or advice with that. And we've been advising employers on that for the last few weeks as well. So certainly reach out if you want to.
Thank you, Nadine. So I wanted to spend the last 10 minutes talking about next steps. Where do we go from here? I know those are a lot of questions, but I did get a couple more really good questions that I'm hoping we can just really quickly cover, and then we'll do 8 minutes for the where we go from here. So the first question came from Marilyn. Marilyn, do you want to kind of jump on and ask your question as it pertains to obligations to sponsors and donors?
Can you hear me?
Yes.
Okay, great. I wanted to know if anyone can comment on obligations to sponsors and donors who have already paid and received charitable receipts.
So I know very specific, and I didn't share that with everyone in advance, but a lot of the associations we work with have sponsored events. Sponsors participate. Sometimes it's charitable. We have a few associations who are actually charities as well. They've paid. Some of the money has likely been used to cover some of the expenses, and they've already received charitable receipts.
So I would think, again, it's going to depend on the circumstances. So if I'm understanding correctly, a party has sponsored a particular event,
Yes.
and now that event is in question. Well, I would think that if the event is postponed, then it might be as simple as having a discussion with the sponsor and letting them know that the event is still going to go ahead in the future, and the sponsorship money will be applied toward the event when it does happen. That might be a resolution might be as simple as that. Obviously, I appreciate there are going to be more complicated questions, particularly if events are canceled rather than postponed. But I think it's going to depend on the circumstances, and particularly, whether money was given or intended to be allocated for a particular purpose, and things of that nature.
If I might contribute just as a planner, I know I've been a part of many of the webinars lately, and one of the pieces of advice was specifically around the sponsorship and how, because some associations, that's their lifeline, and having to return all of those sponsorship dollars could in fact literally sink the association. And one of them said to really dig in on a case-by-case situation as to what was their intention, what was the ROI that they were looking for in the event that they were sponsoring, and find a new creative way in this calendar year to address that ROI. It may not look exactly what they were looking for at your event, but is there a creative way that you can address that ROI so that they are still seeing the value in their investment in your event, but it's delivered in a different way. So I don't have a tax implication or returning the funds, but that was just an idea is for us to think differently about delivering ROI for sponsor dollars that have already been submitted.
Thank you. So shifting now to sort of next steps, where do we go from here? Obviously, we're going to be a lot more diligent when we receive contracts from AV companies, from venues, but we had a lot of questions on this. I think I saw Liza on the line. If you want to jump in and ask your question specifically right now, that would be wonderful. And I'm happy to ask the question on Liza's behalf. So the question from a few people, Roma, some other clients, was what are terms we should be looking at to add to contracts to protect our clients in the future? And what are the single most important takeaways to apply to future planning for events and contracts? Maybe Heather, we'll start with you.
How long do we have, Bailey? Do we have another hour?
6 minutes.
6 minutes. Okay, good.
3 minutes. I would like to thank all of you.
So I think there's too many to mention. Let's just say that first and foremost, there always was a need to be very specific. And I think that's one of my key takeaways is that it is up to us. I think the top thing to remember is that contracts have always been created by legal counsel to protect the party that issues the contract. And it is up to us to be as savvy in returning and negotiating that contract as the legal counsel that created it. And I think going forward, my opinion is that those contracts, just as we are finding time on our hands, I think those contracts by those legal teams are going to become even increasingly tighter. Lessons learned from this, I think there's going to be looking at revenue streams and locking those into contracts. I think we're going to be looking at the costs of doing business higher because there's compressed inventory, there's compressed timelines, they need to recover revenues. I think there'll be higher minimums. I think we have to leave things really specific and not leave anything to vague terms. I think we'll have to protect our rights as an equal partner in the piece of business, as they do in presenting the contract to us. And as Redstone knows, I've said for years now that quite often it's about what's not in the contract that protects us as the event host than what is in the contract that protects the venue. And that's not from an accusatory thing. It's just a reality that we have to really be looking at what is not in the contract that will protect us. I have a feeling that we are going to have to plan conservatively. Actually, I think Vicky had a question in the chat feature about the tourism industry, and Tourism London, kudos to them. They put out a communication a couple of weeks ago, and they went back to one of the experts that studied the implications to tourism after SARS. And one of the findings was that people were keen to do tourist activities, but they did them in their own backyard. They weren't traveling, nationally or internationally, but there is a pent-up desire to do things locally. So I think we need to take lessons from SARS and be proactive and search out those people that studied what happened, so we can plan to move forward after this. But I would say that people will crave the connection, but the finances and the budgets may not match that craving. So even though people want to come back to events, if they're funded by their employer or they're funded by a sponsor or whatever, those funds may not be there for them to come back to your events. So I think we have to really plan conservatively. And I think we have to plan with flexibility in our contracts. So we need to look at our minimums that are they realistic? Are we looking at cutoff dates that are realistic with this new hesitation to travel? Are we looking at room block deadlines and commitments with that kind of flexibility in mind? And another one that I really think is prudent, and I don't have a crystal ball, so please know that this is just coming from my speculation of what I think we have to also protect ourselves from venues that may want to cancel on us. Because there's an opportunity to take a bigger, better, whatever piece of business that may come along. And so I know definitively that most venue contracts do not have language that protects us if they cancel. And I personally believe that this is going to be even more important to have that language in there that protects us if they choose to cancel for a business reason to have more financial impact on their bottom line. And that, so jaded, I don't say that in a jaded way, but I just say it in a cautionary way. That those are some of my thoughts about moving forward.
No, thank you. And I feel like you're on to a really great topic for our next digital roundtable is really where do we go from here? I think it's a little too soon to know, but something that we're definitely all going to keep a pulse on. So with that, I'm looking at the time. I really want to be mindful of the time, those that have joined us. I want to thank everyone for taking an hour out of their day and their lunch to join us. Thank you to our panelists, to Jonathan, to Heather, and to Nadine for your wisdom and your insight. If anyone has any additional questions, their contact information can be found here. I know a lot of clients, a lot of people on this line had very, very specific questions to their contracts specifically. So I think we have a wonderful panel of resources, and you should reach out if you have more questions Thank you on behalf of Redstone for participating. Thank you to our clients for continuing to have trust in us, that we will help you navigate through this. And we're your partners. We are here to help in any way we can. So please don't hesitate to reach out to myself, to Carly, to any of your account managers or directors to kind of figure out next steps. In the next day or so, we're going to be launching our digital event portfolio. So all the things that we can do to keep your members, your sponsors, your donors, your anything, your people in your industry engaged and online. Even something like this, a session that we just did for your industry specifically, is a way we'd love to help. So stay tuned for that marketing information so we can keep all associations relevant during this wild time. Thank you again. Have a great afternoon, and we'll talk soon. Bye, everyone.
Really?